Hello everyone, welcome back to my channel. I'm Michael Carbone. I'm a business and immigration attorney in Staten Island, New York. And today I want to talk about whether you can naturalize and become a US citizen if you have a conviction on your record for disorderly conduct under the New York Penal Law, section 240.20. Before I dive into this topic, if you have any questions or you want to start a conversation, please drop a comment below. Otherwise, if you want to set up a formal legal consultation with me, visit us at carboneattorneys.com. We have a button in the top right corner of our website. Click it, fill it out, and we'll get back to you as soon as possible. So when it comes to naturalization, one of the components of that process is showing that you have good moral character. Now, depending on your case, you will either be subject to a 5-year statutory period or a 3-year statutory period if you're married to a US citizen. So if you are subject to the 5-year requirement from the date that you file your naturalization application, you must prove that you have good moral character for that 5 years prior to the date that you file. Now, when it comes to good moral character, USCIS wants a full explanation of your criminal history. Now, you might have nothing on your record. You may have never been arrested. You may have never received a ticket or cited or anything of that nature, and that's great. The good thing is that if you do not have a criminal record, that's just one barrier that you've avoided in this process, and you're more likely to be able to show that you have good moral character, and therefore you should get an approval on your application and become a US citizen. Now, when it comes to specific criminal convictions, obviously no two charges or convictions are the same, but for the purpose of this video, we're going to talk about disorderly conduct. So under the New York Penal Law, disorderly conduct is actually classified as a violation. So it's below a misdemeanor and it's below a felony. So when it comes to disorderly conduct, it actually covers a wide range of activity. So you can be charged with disorderly conduct for fighting in public, causing a public disturbance, making too much noise. There's a laundry list of activities that are covered under this statute that would authorize the charging of disorderly conduct against you. Now, when it comes to the naturalization process, you obviously want to disclose your criminal history. So if you've ever been charged, if you've ever been convicted of an offense, you do want to disclose that to USCIS, as they will conduct a background check on you. And if you don't disclose it, they will find out anyway. And you don't want to be in the situation where they're presenting your record to you and you say, oh, sorry, I forgot to disclose that to you. It does not look great for your application. So you want to be forthcoming. You want to reveal that information sooner than later. Now, disorderly conduct has been found to not affect good moral character. At the moment, there are no cases or precedents that would suggest that a conviction for disorderly conduct would show that you do not have good moral character. Instead, individuals with disorderly conduct convictions have successfully been granted naturalization and have become US citizens. Now, obviously, you could have other components of your case that could result in a denial. However, if disorderly conduct is your only concern, you should not have any worries, as it should not be an impediment to having an approval on your N-400 and therefore becoming a US citizen. So that's it. That is disorderly conduct and the naturalization process, and obviously good moral character. If you like this video and you want to see more, please like, subscribe, and I'll keep making them.